First, allow me to apologize for starting quite late. So I will be saying a few words in Arabic, and then I'll switch back to English, the language in which the rest of our webinar will continue. So أهلا بالجميع.
I would like to welcome you all. I would like to apologize for being late. I would like to draw your attention to that the meeting is going to be in English, but the Law for Palestine allows for the interpretation service. If you would like to continue watching in Arabic, you need to press on the globe at the bottom where you have interpretation button, and then you can listen to the whole webinar in Arabic.
For Arabic speakers. So I would therefore like to ask you, to ask our English participants, whenever they speak, to bear in mind that there are interpreters doing some really hard work there. So, okay, before anything starts, I will give the floor to Francesca Albanese, Head of Migration, Forced Displacement and Statelessness Program at the Arab Renaissance for Democracy and Development, ARDD, who will be saying a few words in the opening of our webinar. Francesca, please.
Thank you, Abdelghany. And just a quick word to welcome you all on behalf of both Law for Palestine and the ARDD. It is a pleasure to have you with us today for a discussion that is timely and necessary on how anti-Semitism, a tragic phenomenon that exposes one important phase that lingering racism of modern society as the important phase of the lingering racism of modern societies has been increasingly utilized for a political purpose. Combating anti-Semitism, as well as Islamophobia and any other form of racism or bigotry still rooted in our societies, is both a necessary part of our commitment and a duty under the rules of international law that prohibits discrimination and hate speech. In the meantime, such a compelling struggle should not be used as a tool to suppress critical thinking and critical voices. As human rights organizations who stand for the primacy of the law, both Law for Palestine and ARDD accord critical importance to this issue. And this is why we convene this event today. And I'm so excited to see such an excellent group of experts whom I salute and thank for their presence joining us. Before leaving the floor to the moderator, as a representative of ARDD, I wish to express my gratitude and appreciation to the friends and colleagues at Law for Palestine for their commitment to international law and their impressive work in the field of justice in Israel-Palestine. Law for Palestine, ARDD is proud to work the path of search for justice with you. And without further ado, I wish all of us a fruitful discussion.
Thank you, Francesca. Okay, so without losing a lot of time, I will go ahead and introduce our speakers and our commentators. We have 3 speakers and 3 commentators. We have really a brilliant panel. So we have with us Professor Richard Falk, Professor Emeritus of International Law at Princeton University and former UN Special Rapporteur on Human Rights in Palestine. We have Professor Neve Gordon, Professor of International Law at Queen Mary. And we also have with us Giovanni Fassina, lawyer and program director at European Legal Support Center. Each speaker will be speaking for about 10 to 12 minutes, and then we will move to our commentators, whom I will be introducing after we hear our speakers. So our speakers, I expect, will be walking us through what really is the problem. Is it the IHRA definition, or is the problem broader than that? And how to balance the need to combat anti-Semitism against the need to protect Palestinians' just cause and the need to protect critical thinking, really, as Francesca just mentioned. And we would also be hearing perhaps more from Giovanni in the end, more about the means available to Palestinians and their supporters in an atmosphere like the one we just described. So we shall start with Professor Richard Falk. Please, Professor Richard, the floor is yours. We can't hear you, Professor Richard.
Yeah. Thanks very much for your introductory words, and I'm very glad to be taking part in this important effort to unravel the confusion around this whole subject of anti-Semitism as a violation of fundamental human rights, to the extent that it is a form of hatred of a particular ethnicity, the Jewish people, and the confusion of that with, as Francesca suggested, the use of that symbol of opprobrium, symbol of unacceptable behavior and attitudes, the confusion of that with a politics or a policy tool that's designed to shield the state of Israel from responsible and deserved critical assessment. And in my view, the embodiment of the Zionist project in the state of Israel as it has unfolded creates a policy imperative to create that confusion. In other words, it's not only opportunistic, it's embedded in the whole undertaking of a Jewish state in a non-Jewish society. How can one do that without creating a lot of obscurity about what is taking place? And that obscurity aims at the perception that attacks on Israel are really attacks on the Jewish people. And it's a way, it's what I have called the politics of deflection, leading the discussion to be about whether or not criticism of Israel or the proposed definitions that encompass criticisms, proposed definitions of anti-Semitism that encompass criticisms of Israel are to be accepted. So it's a shift from the justifiable and increasing level of consensus that Israel is an apartheid state. And this is a way of avoiding that conversation and having this conversation. And I noticed when I was special rapporteur about 10 years ago that Israel decided that it would no longer try to, in the UN settings, Israel would no longer try to substantively refute criticism of its policies and practices but rather would concentrate on attacking the credibility of the person or group that was mounting those criticisms. In other words, that's when I first realized that this was fundamentally an effort to shift the conversation and attention of the international community away from Israel's wrongdoing and try to pin that label of anti-Semitism, an alternate way of wrongfully acting on those who criticize Israel. It's a kind of linguistic acrobatics that is designed to achieve a very unacceptable result, which is to continue to be insulated in their practices that have been repressive toward the Jewish, toward the Palestinian people at the hands of a political arrangement that has been increasingly characterized, as I said, as a form of apartheid. And this silencing of critics has become official Israeli policy and has been promoted by this attempt to spread the acceptance of the broader definition of anti-Semitism as embracing Israel. But the underlying impulse is not the redefinition so much as the diversion of attention from the crimes and wrongdoing of the Israeli state. And it's a great disservice to the effort to protect Jews against genuine anti-Semitism because it leads to this misunderstanding of what constitutes anti-Semitism and necessitates the kind of clarifying effort that this meeting is dedicated to achieve. In other words, it's trying to disentangle the misapplication of anti-Semitism from a focus on achieving some sort of justice, even belatedly, for the Palestinian people. And that should be the central international effort. And therefore, what I hope, and I think many others who have been dedicated to the protection of the human rights and the basic aspirations of the Palestinian people that were displaced and destroyed, that one can refocus on that struggle and not be diverted by this kind of propaganda technique of confusing the issue, confusing the critics with the wrongdoing, and leading to lots of public misperception concentrated here in the United States by efforts to criminalize nonviolent forms of opposition to Israel's practices and policies. And so the BDS campaign is a casualty of this anti-Semitism, this effort to portray such initiatives as anti-Semitic. And so this kind of exercise in clarifying the language of anti-Semitism is essential to refocusing the struggle for justice in Palestine. Let me stop there.
Thank you, Professor Richard. We will move to Professor Neve, Professor Neve Gordon, who works in the UK and in the UK academia, which has undergone a lot of attacks against academics in the last few months, really, for their statements on Israeli policies or on the Israeli state. And he wrote a piece in which he was wondering whether Albert Einstein, according to IHRA definition, would be considered an anti-Semite. I think he did so, right? So Professor Neve, please, the floor is yours.
So thank you, Abdelghany, and thank you, Law for Palestine, for inviting me, and thank you, everyone that came today. And yes, I thought I would talk about what this IHRA definition in the context of the universities in the UK. I'm also the head of the Committee on Academic Freedom of the British Society for Middle East Studies. And so we receive quite a few complaints through this professional association, which is the biggest professional association for Middle East studies across Europe. And so, as maybe some of you know, in October 2020, the education minister in the United Kingdom sent a letter to all the universities across the UK and told them that they must adopt the IHRA definition of anti-Semitism. He sent it in October. He said, I want it to be adopted by Christmas. And if it's not adopted by Christmas, there will be financial punitive results. Namely, universities that fail to adopt it will be fined in some way by the government. So to the best of my knowledge, 2 years, less than 2 years later, now over 200 universities, colleges, and other higher education institutions in the UK have adopted this definition, including the university where I teach, which is Queen Mary University. Now, as Richard before me, who's also a colleague and a close friend, said, what this definition basically does is it changes the traditional meaning of anti-Semitism so that the focus, instead of being hatred of Jews, that the idea that Jews are either naturally inferior or evil, or there's a belief in a worldwide Jewish conspiracy and all these kinds of tropes, and puts the focus on harsh criticism of Israel and the government of Israel for its rights abusive policy. And so for basically, if I were to come and say that the controversial 2018 nation-state bill, which reaffirms the Jewish character of the state, and legalizes discriminatory policies against Palestinian citizens of Israel, and I would say that this is a clear manifestation of a racist law. According to the IHRA definition, a person who calls the state that legislated the racist bill racist is anti-Semitic. But a state that legislates racist legislation is racist. So, according to this definition, I have a major problem. Now, this is really, really serious business. And it's serious business, again, if I quote Richard Falk, because anti-Semitism in its traditional sense is alive and well. It's kicking. And I moved to London in 2016. I have two children that go to high school in London, and both my children have experienced anti-Semitism in their school. So what we have here is actually a definition that does a kind of cry wolf, while the real anti-Semitism is erased and deflected. Now, in the UK, there's been scores of cases of academics and students that have, in the past 2 years, been subjected to investigations, disciplinary hearings. There have been cases of people that have been fired from their jobs and then reinstated. And so what you have is a whole kind of situation where people are being harassed, basically, using this definition. Now, what we know from looking at these cases is that in practically none of them was a case substantiated. So what we have is actually students sitting and looking at people's, let's say, Twitter accounts, going back 4 years, 5 years, and looking at every tweet you tweeted, every tweet you liked, every tweet you retweeted, seeing if any of them fall under the definition of the IHRA as anti-Semitic, and then filing a complaint. The people the complaints have been filed against then have to go through 7 gates of hell in terms of they are ashamed because they're blamed of being anti-Semitic. Then they have to defend themselves that a criticism of Israel is not anti-Semitic. They have to go to meetings and disciplinary hearings. Sometimes they have to hire lawyers, as Giovanni will tell us in a minute, and so forth and so forth. And this creates a kind of chilling effect, not only on them and in what they will do in the future, but on all the people around them that are aware of these disciplinary hearings and so forth. And what you have is a kind of silencing effect that this definition has done. And so what I would like to say is that how we have to understand this definition. Richard told us that we have to understand it as a kind of deflection mechanism. I would like to take that a step further, and I would like to suggest that it does much more work. Richard and Virginia Tilley wrote in 2017 the first apartheid report under the auspice of the United Nations that basically claimed that Israel, from the river to the sea, is committing the crimes of apartheid. 2 years later, 8 Palestinian human rights organizations wrote a similar report and submitted it to the UN as a shadow report. A year later, B'Tselem followed suit, then Human Rights Watch, then Amnesty International. So there is now a consensus among the human rights community that Israel is committing the crime of apartheid. I would like to suggest that this definition is an apartheid enabler. It's an apartheid enabler because anyone that lays the claim that Israel is committing the crime of apartheid is automatically, according to this definition, branded as an anti-Semite. And therefore, the definition is part of a whole apparatus that is used to basically enable the apartheid machine, to shield it, as it were, from any kind of criticism, so that it can continue going on and on and on. And so what we need to think about very carefully, and I'll end with that, is how do we undermine this definition while still being vigilant against the real manifestations of anti-Semitism that are on the rise across Europe and North America and in other parts of the world. So I'll stop there. Thank you.
Thank you very much, Dr. Neve. Okay, we'll be back to the issues raised by Dr. Richard. Was someone speaking? By Dr. Richard and Dr. Neve. Certainly, when we hear from our commentators, now we'll move to another area where Giovanni Fassina will be telling us more. He's a lawyer and mainly, and he will be telling us more about how the anti-Semitism definition plays out at the judicial arena. Giovanni, please, the floor is yours.
Yeah. Again, I would like to thank you for Palestine for inviting us as ELSC, and it's really an honor to share this event together with Neve and Professor Falk, which I admire both a lot. So first of all, I will tell you just a few words about our organization, so to better understand what we do and what is our work regarding the IHRA. The European Legal Support Center is the first and only organization that provides legal assistance to advocates for Palestinian rights in Europe. We've been established in 2019 as an initiative of a Palestinian NGO network, which is a network of 250 Palestinian civil society organizations, and of a Dutch NGO, the Rights Forum. And what we do, indeed, we work in many different jurisdictions. We are based in Amsterdam, but we work in the UK, Germany, Netherlands, and we work basically as a filter between the clients and the lawyers, because as you can imagine, it's very difficult for us to operate in so many jurisdictions. I do not know Dutch law, I have to admit, nor British law. So we have, in the last years, we assisted hundreds of students, academics, civil society organizations, artists, cultural organizations, also Palestinian human rights organizations as well, and dealing with a broad range of issues, from unlawful dismissals, smear campaigns, closure of bank accounts, and we have seen different tactics and different kind of attacks which has been used in order to harass and silence people. And of course, the IHRA is one of the most relevant, I would say, tool that has been deployed in the last years to this purpose. So during my presentation, and I really ask moderator to stop me if I'm going to speak too much, I will just tell you a little bit more from our experience on how it is like to challenge the IHRA. And what is the impact overall of the IHRA? So first of all, indeed, the IHRA is important to remember. It is not a form of primary legislation. It's a form of soft law because it's not legally binding. But in this context, many European states has used the IHRA as a source of domestic decisions and policies, which again, they clearly target advocates for Palestinian rights. And even if it's not entered in national legislation, IHRA has been treated as legally binding de facto by public and private actors. So these European governments, and I'm referring especially to Austria, Germany, and UK, United Kingdom, has adopted de facto the IHRA as a source of anti-discrimination policies, right? That complete critique of the state of Israel with anti-Semitism. And this conflation need has resulted in punitive policies and practices that violate fundamental rights and create a chilling effect. So I'm going to tell you a couple. We had so many cases just in the last 2 years. We dealt with over 140 cases in different European countries, and I think we could stay here for at least 1 hour telling you many different stories that we addressed. I deeply apologize for this. Anyway, so I'm going to focus on Germany. I will give you a few, will provide you with a few examples. So basically, in Germany and Austria, national parliament have adopted anti-BDS motions. Anti-BDS motions are parliamentary motions adopted by the federal parliament, but also by local municipalities. These motions, some of these motions are recalling the IHRA in the preamble, and then they are basically equalizing the BDS movement with a new form of anti-Semitism, and they are calling for public and private bodies to not award funding to BDS or any kind of activities connected to BDS, and to not provide any public facility to BDS or related event. Again, our motions are not legally binding. Nevertheless, we have a huge amount of cases where public bodies, especially municipalities, refused to grant rooms to BDS events, or also to groups that maybe are not part of BDS, but they are accused to be BDS. The positive aspect is that every time the decision by public bodies have been challenged, we've been successful. I'm gonna then share in the chat some summary of these cases, because a lot of them are in our website. But the most important thing is that in the last 3 years, we have now a growing body of jurisprudence in Germany, of German courts acknowledging very, very clearly the fact that the BDS is a legitimate human rights movement. The courts acknowledge that the anti-BDS motion, as a piece of soft law, cannot trump fundamental rights like freedom of expression, freedom of assembly. And every time acknowledge all our claims, basically. Most importantly, it's really for me important to remember the most important case is still pending, which is a case which is called BT3P, Bundestag Free for Palestine. So we have 3 activists in Germany who have been legally challenged. They are challenging legally the motions adopted by the German Bundestag, by the German parliament. And this, from a legal point of view, it's very tricky, in a sense that indeed it's a political motion. So since it's not indeed a piece of legislation, it's a bit more difficult to fight it or to protest it like you would do with a normal law, where you can file a constitutional complaint, for instance. So in this case, there is a pending case before the administrative court. Actually, we lost the first instance, and now there is the appeal. And again, I will share the link, because it would be really important if anyone here interested could support and speak about this case, because this case is going to be crucial for shutting down these motions at the national level. So this is the situation in Germany and Austria, which again, it's somehow dramatic, but on the other side, I really want to stress that every time we fight this and we bring these cases in court, we win. Because, I mean, luckily, I would say, like the European legal framework when it comes to freedom of expression, freedom of assembly, it's quite, you know, it's absolutely in our favor. The other situation is in the other country where the IHRA has been adopted mainly indeed is in the UK. And also here we had indeed similar cases where we could really see how the IHRA has been employed. And I want to tell you like one case where we had a company who adopted internally the IHRA, and they just hired a new person. And after having hired this person, they immediately withdraw the job offer because they argue they did a double check on their social media, and this person during the last war in Gaza, this person posted some posts in solidarity with Palestine, and this person retweeted a video of Norman Finkelstein, or made a comment where this person was observing this person was commenting the fact that individuals who are openly expressing intolerance or hatred toward Arab, blacks, and other minority were also supporting the ideology of Zionism. Well, according to this company, these comments amounted to unlawful anti-Semitism and were therefore not compatible with the new policy adopted. Of course, we challenged this immediately through our lawyers. We sent a letter and we threatened them to sue them. And of course, the company reoffered immediately the job to this person. Again, in the UK also the law is completely different. But again, even there, there is a very clear set of laws that protect individuals from discrimination for political beliefs and that protect freedom of expression. And besides that, indeed, as Neve knows very well, we assisted dozens of academics and students who have been put under disciplinary investigation because of what they tweeted years ago. But also we had a case where a person was put on investigation because he attended Black Lives Matter protest, and during that process he spoke about Palestine. And again, every time we were involved and we challenged very openly the whole investigation. We challenged the use of the IHRA. The universities decided that there was no case to answer, and they immediately dismissed the complaint, which is indeed another good sign on the fact that these policies are adopted under political pressure. But when it comes to but when you challenge it and when you push the public body to actually apply and comply with the primary regulation legislation, they always do the latter because the IHRA doesn't stand basically. So eventually what we notice is indeed that the IHRA has created a political framework that has a direct influence on public and private bodies. This is clear as a result in restrictive punitive measures. And yes, again, it's correct that the IHRA is not being incorporated into existing legislation on hate crime or discrimination, so does not directly interfere with domestic law. However, the extensive and sustained pressure on public and private actors to apply the IHRA and also to apply these anti-BDS resolutions has resulted in situations where these non-legally binding and political instruments are rapidly acquiring a de facto force of law. At the same time, it's absolutely possible to challenge this in many ways. First of all, I would really recommend any one of you to report incidents to us. We have a very quite a small but very dedicated team of junior legal officers and lawyers who will get back to you very quickly. And again, the most important thing, if we want to push back, is to challenge it. We can challenge it in many ways, politically, of course, campaigning, but also legally. So yeah, I will put a lot of links now in the chat. And yeah, thank you again.
Thank you very much, Giovanni, for the very interesting presentation. Of course, the problem really, as you probably also mentioned, is not always that things may translate into judicial proceedings, but also the mere fact that we're having this discussion is already alarming, because the problem really is how is the atmosphere that the IHRA definition has created. It's the self-censoring. For example, me as an Arab academic based in the UK with a strong interest in the politics of my region, let alone on Palestine. So me, as well as my friends, we engage in constant activities of collaborative self-censoring and paranoia and anxiety. That's our lives. Over anything we want to write, over determining our research interests. We always talk to each other. So the problem is that it doesn't make it to the judiciary, and it doesn't make it to disciplinary actions all the time. It's already living with us in our everyday lives. Okay, so
just to add very quickly on this, we always try to avoid to go to court, frankly, especially in the UK, because it's extremely expensive, So what we try to do is always to preempt that, because if we keep that at university level, it's actually better. But of course, if it's worth it, it's possible to go to court, but it really depends on the kind of jurisdiction. Just to add this.
Yeah. Okay, perfect. We will move now to our commentators. We'll hear their comments. After them, we are hoping to have time for a good Q&A session, an actual Q&A session where those who want to ask questions can actually speak and tell us their questions themselves. So I'll give the commentators the floor. Each of them will speak for 3 to 5 minutes. We have 3 commentators. We will start with Ilise Cohen, anthropologist specialized in Jewish studies. Ilise, please, the floor is yours.
Thank you, everyone. It's great to be here. Exhausting topic, clearly, and really important, incredible work happening everywhere. Honored to be here. I guess I just wanted to add, I really appreciated everyone's comments, and I'm not exactly sure how much I can say in 3 to 5 minutes, but I do want to add these few things, and maybe it'll be part of the conversation. One is that as a Sephardic Jew and representing groups of Sephardic and Mizrahi Jews and Jews of color that I'm connected with, being able to talk about Israel as a racist endeavor and the kinds of racism in the establishment of the state, pre-state and after its establishment, is a key part of even political and social and identifying factors in many of our lives. So I wanted to put that out there. I am from the state of Georgia in the United States, and we've already seen that it's been codified. IHRA has been codified as an executive order. It's now being codified in my state as we speak. And even as we fight against it, some of the arguments that we have is actually that it is an act of anti-Semitism. This IHRA policy or IHRA definition singles out Israel from every other country in the world. It also singles out Jews from any other group in the world. It singles out Jewish people to only be a particular kind of Jew. It also forces us to be related to or connected to a self-determination that is related and centers Israel, which is also not okay. It's anti-Semitic in the fact that it allows Israeli exceptionalism around apartheid. So I just wanted to put those out there. And I also wanted to say that in terms of IHRA, I think it really missed its mark with the Swedish Prime Minister and whoever else decided to keep promoting this. And I keep trying to do research about how it really developed. And maybe some of you can answer that, is that it actually started with the words of, in the spirit of the Stockholm Declaration that states, with humanity still scarred by anti-Semitism and xenophobia, the international community shares a solemn responsibility to fight those evils. It missed the mark. The mark is that there's white nationalism, is that there's neo-Nazi movements, is that there's Christian anti-Semitism, and that there's Christian hegemony, and all those things operating together both in North America and in Europe are the parts of the things that we actually need to name. And when we don't name those things and instead frame it in an anti-Semitism framework, and we also don't bring in xenophobia, then we start to separate all the groups, which hence, I think, Giovanni, you were talking about how intersectionality is a threat. We're hearing that everywhere. So we hear it as the Jewish community thinks it's a threat, but really it's the threat also for state actors and non-state actors who really don't want people to pursue forms of justice, and who also really don't want to undermine nationalism, state-sanctioned violence around nationalism, and how that nationalist fervor attacks all of these groups, not just Jewish people. So I think those are some of the key aspects. Let me see if I have anything else. I don't know if my 3 to 5 minutes is up. Do I have another minute or so? Okay, great. I also just wanted to say, there's always going to be a nationalist propaganda, no matter what we do, whether it's connected to Israel or not. Call Israel the state that it is, that it has nationalist propaganda, like any of the states that we belong to, and take it out of the context of anti-Semitism. And the exhaustion around, I think, Richard Falk, you were talking about distraction, and then Neve, you were talking about you want to take it even further to enabling apartheid. And I just want to add to, this is the exhaust of racism. This is the exhaust where you are constantly peddling, Giovanni, what you just shared about, or Abdelghany, what you just shared about, you don't even know what you can research or what you can say in your academic space. As a Jewish studies scholar who was targeted by the Jewish community in my state and no longer has a contract to teach Jewish studies, the only Jewish studies professor, because of my work on Palestine, I know that it actually has deep roots to unearth us from our work in the world. And as an academic, I feel like that's the place where that kind of exhaust, if we don't take it out of and name the real things behind this, both advocating for Palestine, but also that nationalism that I was talking about, that we actually miss this mark. I'll stop there.
Thank you very, very much. We'll now move to Professor Andrew Gordon, Professor of Comparative Cultural Studies. And after Professor Andrew, we will hear Mr. Anis Kassem, a renowned Palestinian international lawyer and a member of trustees of Law for Palestine. First, Professor Andrew, please, the floor is yours.
Well, I regret terribly that we have 2 anthropologists on this committee, and it's so very, very nice to join you, Elise. And it sounds like you're doing and have done extraordinary work. I'm very struck by our understandings of anti-Semitism and the anti-Arab feelings that I have seen among Israelis, and the sympathies with apartheid. That the essential feature here, which I feel, is that there is an assessment of individuals as they're being biologically incapable of change and biologically incapable of different forms of thinking. I agree with Dr. Falk in his assessment that this is somehow a violation and a distraction from the real issues and critical thinking. But I think at root, at the very basic levels of thinking, that we find that anti-Semitism, that the anti-Arab feelings are basically misapprehensions of the differences, the cultural differences that we see that have become in our minds biological differences. That I don't see any hope at all for the dissolution of apartheid, for the changing of our discourse, such that we can be critical of policies as long as we are seen as biologically, therefore existentially committed to certain points of view. What I mean to say is this: that the Jews and the Israelis who tend to subscribe to certain apartheid policies tend to think of biologically inferior, biologically different, biologically incapable those who are opposed to them. This not only extends to Arabs and would extend to all of those who sympathize with Palestinian rights. The challenge ahead of us is to think differently about difference, that it is not biological, that it is not existential, that we need to consider that it is possible to move beyond the fact that people are committed to certain points of view. What I mean to say is that once we begin to think in terms of our expressions of ideology, expressions of policy, expressions of objectives as that which is biologically encoded within us, we have no chance of change at all. That it is how we appreciate other people, how we appreciate other points of view. If they are biologically set, even though we may phenotypically look Jewish, have Jewish names as such, our non-subscription to the policies of Israel suggests that there is a wholly different biology at work, that we are masquerading somehow as Jews, but we are really against them. The trick here is to go beyond this sort of existential commitment, this sense of the biologizing, so to speak, of political and cultural difference. I think I'm not, this occurs to me very much as I think of Israelis that I know who are tremendously opposed to Arabs just because they think that they're existentially committed to different ways of thinking. Equally, we see in the United States, those who are opposed to those who do not look exactly like them, is that they're existentially committed. We need to dissolve these forms of thought that biology is in fact culture. That's primarily what I'm thinking today. I may think somewhat differently another day, and perhaps I haven't expressed myself as clearly as I would like, but I would be willing to take whatever questions for clarifications as may be presented right now.
Thank you, Dr. Andrew. And speaking of which, I would like to urge our speakers to already post their questions or request the floor, because we have now Mr. Anis Kassem, and right after that, we would be hopefully having enough time for enough questions. Mr. Anis, please.
Yeah. Thank you, Abdelghany, and I do appreciate the presentations made by the three distinguished speakers and the two commentators, who all left me very little to say, actually, but I try to venture and to add something that I recalled when I was a freshman student some years back. Don't ask me what year. I was reading, when I was a freshman student, I read a piece of literature by an English writer called Robert Thowles, titled Emotional Meanings. In that piece, he wrote that it is difficult to discuss a controversial matter in psychology without using words which rouse strong emotions and confuse all issues. Words, therefore, cannot only refer to a subject matter, but also suggest an emotional attitude toward them. Based on these statements, I venture to say that the word anti-Semitism does not stir any emotion in me. I didn't live the pogrom of Russia and East European countries. for the horrific experience of Europeans in their intellectual despised description of Jews living in their societies. However, it is a fact that, as I learned later on, anti-Semitism is a term that stirs a lot of emotions in the mind of a European. To me, as a Palestinian and an Arab, we grew up without such anti-Jewish prejudices. Thus, the term anti-Semitism does not create any emotion in me. Having said that, I don't mean to say that I am numb to that term or to the characterization of people who are anti-Semites. No, I don't deal with anti-Semitism except in the context of fighting any abuse of human rights based on any ground. Religion, color, sex, age, whatever it is. I am against it because I am a committed human rights lawyer. However, I am not oblivious to the custom-made definition of IHRA, which is designed to shield Israel of any criticism. About half of the 11 illustrations attached thereto deal with Israel. No wonder that it was the definition adopted by the US Department of State and ultimately became the policy of the policy platform of President Trump executive order, which in effect undermined the Free Speech Amendment, which is the First Amendment. Strangely enough, Trump's order effectively adopted the anti-Semitic definition of Judaism and coined its relationship with European Jews. However, it is the Zionist tradition of forging terms and concepts to employ them and Jewish supremacy. For one example, if we take the statement of Benjamin Netanyahu commenting on the ICC probing of Israel's exercise or practices in the occupied territories, he immediately called such a probe pure anti-Semitism. On the other hand, the Star, when she wrote on her Instagram that she supports the Palestinians, that prompted the pro-Zionist enterprise to accuse her of anti-Semitism. She was not attacking Jews. She was not attacking Judaism. She was only supporting the Palestinians. So this is a tool. Anti-Semitism has become a tool of silencing any comment against the Zionist enterprise. And this tool of silencing, or this art of silencing, is not limited only to anti-Semitism accusation. It was used against the UNRWA when UNRWA was being attacked by the Zionists and by Trump and Kushner. That is, it is perpetuating the problem of the Palestine problem. It was only historically, like Professor Keith Whitman wrote a book some years back when he said the invention of ancient Israel is the silencing of Palestinian history. So silencing is an art of the Zionist propaganda. On the supremacy issue, I would like to try two laws just to demonstrate the point. In the Second World War, the International Tribunal of Nuremberg, in deliberating the crimes committed by the Nazis, argued that its jurisdictional authority is derived from the concept of crimes against the common humanity of all victims. The tribunal did not give regard to the religious or national affiliation of the victims. In contrast, Israel in 1950 passed a law called the Nazi and Nazi Collaborators Law. It classified the Nazi crimes into the crimes against Jewish people and the crimes against the humanity. So the Jewish people are different set of human beings. The first set includes 7 specific acts. These are killing Jews, causing serious bodily or mental harm to Jews, placing Jews in living conditions calculated to bring about their physical destruction, imposing measures intended to prevent birth among Jews, forcibly transferring Jewish children to another national religious group, destroying Jewish religious or cultural assets or values, and inciting hatred of Jews. The class of crimes against the other class of human beings who are not Jewish people, they were defined as murder, extermination, enslavement, starvation, deportation, and other inhuman acts committed by against civilian population. Applying this law to the Eichmann case, the Israeli court based its jurisdiction claim to try Eichmann not upon the human values, but upon the alleged legal link between the state of Israel and the Jewish people. The court said that because of that link, then a crime intended to exterminate the Jewish people has a very striking connection with the state of Israel. The court said, this is the state of the Jewish people. The second example is the martyrs and heroes commemoration. The Yad Vashem law of 1953 is another example to demonstrate supremacy of the Jewish Zionist entity. This law was enacted to honor 9 categories of peoples and persons during the Nazi regime, 8 of which concern Jews and the Jewish people. The last category deals with high-minded Gentiles who jeopardize their lives to save Jews.
Mr. Anis, I would like to ask you to conclude in the next minute, please.
I am about to close. If you just give me 1 minute. It is therefore well-established policy in all activities of the Zionist Israeli legislation and practices that Jews, or more precisely, nationals of the Jewish people, are not at parity with non-Jews. Jewish people are not at parity with non-Jews. It is, of course, equally discriminatory whether Jews are elevated to a super status or whether non-Jews are relegated to a substatus level. This racist process runs deep in the state of Israel and is indispensably rooted in the Zionist ideology. Thank you.
Thank you very much, Mr. Anis. Okay, we'll move to the Q&A session, and I think we have a bit of time. We will start with the first question. So yeah, we already have some questions here. Others, please post your questions or request the floor. We have Dr. Salem could you please, Hassan, could you please bring Dr. Salam to the panel? Is he with us already? Salman, sorry. Dr. Salman, sorry.
Yes, in a few seconds. Ready now.
Okay, Dr. Salman, please, the floor is yours.
Hello, do you hear me now?
Yeah.
Perfect.
Yes, all right, okay. Good morning or good evening to all of you, wherever you are. As you well know, when a crime is committed, it is illegal to conceal the crime. It's also illegal to silence the victim. It's also illegal to conceal the evidence or distort it or make it hidden. That is very well known to all of you. In fact, the Statute of Rome, 1889, Article 25, says aiding and abetting a crime is a criminal, individual criminal capacity. In other words, an individual could be called a criminal because they or he or she aid or abet a crime. Aiding, abetting a crime is allowing it to happen or condoning it or making it acceptable or silencing the victim of that crime. So this is well established. Last September, we started in Palestine Land Society of London, we started a competition among young students in Gaza schools. It's called This Is My Village. We asked the student to say where you come from, why are you a refugee, what's your right of return? The UNRWA refused to let this competition known to its students. So we had volunteers to stand in front of schools and distribute the leaflet. It reached a lot of people. 1,800 students entered the competition. Finally, we got the winners judged by university professors, and we announced that. The UNRWA people refused to attend the award ceremony. We then printed Palestine map, which shows the villages from which these refugees come. And we also shown on that where they come from, the number of people who became refugees and where they are now. The UNRWA refused to let this map enter the schools. We wrote to the head of education in UNRWA. We also wrote to the Commissioner General, Philippe Lazzarini. He answered me a letter nicely, but at this moment, 1 hour ago, I was on a call with the head of education in UNRWA. They still refuse to allow the map in their schools, and they could not explain why they prevented the competition of the young students saying, I come from this place, I am now a refugee. Now, this, of course, is criminal act. What do you suggest we do? One thing we plan to do is in next May or June, next HRC session, we'll present a petition on that. Could any one of you please let us know what we can do?
Thank you, Dr. Salman. I think we can discuss that at the Law for Palestine Forum at some point, but not with within the anti-Semitism discussion, I reckon.
Abdelghany, I understand that. My point is very simple: silencing the victim from talking. So also, IHRA silencing the victim from talking.
Yes. Yes, and actually there was a question, but I cannot see it. It's posted anonymously.
Maybe I can say a word to Salman Abu Sita, if that would
Please.
be okay, Abdelghany.
Please.
I mean, Giovanni is here too, and I think Giovanni said it. He's the head of a legal organization also. But he said the law is not what is going to set us free, in a sense. It's not the belief that the law is the answer to these issues is, I think, misguided. We can use the law when it helps us, but we have to remember that international law is created by states and is basically against non-state actors. And the Palestinians are a non-state actor at this moment, however tragic it is. We have to remember that laws within states are the tool of the state. So to come and think that the law will be a kind of mechanism to bring justice to these Palestinian children and to this campaign, which I think is amazing, and I think what you're doing is absolutely just incredible, and that you've got 1,800 participants is just wow. But I think it's actually, if these children would write, if you begin a campaign among children of the world, that it is accepted, and rather than to go to the lawyers, which disempowers the children that you actually kind of tried to mobilize. So continue mobilizing the children. That would be my answer.
Can I just add a word to what Neve said? It seems to me one doesn't have to make that choice. I think that although I share his criticism of the limits of law, it would be useful to expose this experience within the UN framework and to embarrass an organization that purports to adhere to the rule of law by showing what a departure this really amounts to from a human rights perspective. And that has a symbolic value that shapes public opinion as to what is legitimate and what's illegitimate in the world. That's one of the important roles the UN plays. And I wouldn't underestimate that impact. It was very important in the struggle against apartheid in South Africa, that shifting the burden on the politics of legitimacy is underestimated value of UN initiatives. So we must both mobilize the children and do our best to activate the UN.
On a very relevant note to both the UN and also to Dr. Salman's question about silencing some voices or having some voices unheard. So a question that was posted anonymously. So it's not redirected to anyone, but it's also related to the UN. So maybe Dr. Richard would like to give it a go. So the question says, there seems to be a discrepancy between Europe's and the USA's approaches in dealing with this matter. Nevertheless, I'm curious as why the Far East's stance is absent in this fight. So what is the stance of the Far East on this? And then the General Assembly wins have always been The GA wins always come from the allied force of those oppressed or those who know the meaning of being oppressed. And this is why we have more wins in the GA than the Security Council. The question is, should there be a conversation of a potential grand alliance to raise these voices, to go back to the grounds on which anti-Semitism was initially defined and purposed? So it's a tactical question on probably potential instrumentalization of the UN GA. Professor,
I think there's no doubt that the UN has an important role in clarifying the nature of authentic anti-Semitism and being arousing what Neve called vigilance in relation to it, and repudiating the confusion that is caused by identifying anti-Semitism with criticism of Israel. That's a really important distinction, and if it was embodied in a widely supported General Assembly resolution, I think again it would have an important impact on international public opinion, and again it's important in the symbolic domain of politics. I would take the opportunity to just make one other point. It's interesting to observe that Israel has been actually opportunistic in befriending genuinely anti-Semitic governments and placing all its emphasis on this inauthentic use of anti-Semitism. In other words, it's befriended Hungary and other even groups. It has ignored the rise of white supremacism, and it shows a perverse sacrifice of the struggle against the hatred of Jews in order to insulate Israel from its wrongful practices. And this is part, it seems to me, of a diagnosis of what's wrong with the IHRA approach.
Yes. Would anyone else like to add something to this question, or shall we move to another question now? Okay, so shall we move to another question? I think Francesca had a question, right? Okay, Francesca, sorry, before you start. So I would just like to ask you if we can keep the conversation going for 10 more minutes, if our guests don't mind. Yeah? Okay. Francesca, please.
Yeah, I will be very brief, and thank you for the inspiring and thought-provoking comments, all of you. The first question is, it has not been mentioned, but the many Jewish scholars and intellectuals, I think a couple of years ago, came forward, and I think Richard is a signatory of the Jerusalem Declaration on what constitutes anti-Semitism. It's a tremendous piece of advocacy. Why do you think this is not gaining enough traction as a response, as an alternative to IHRA? I mean, of course, I do not expect governments to pick up themselves, but advocates could use it more. And I keep on meeting people who have never read it, who have never heard of it. And the other question is for Giovanni in particular, but happy to hear from others as well. In terms of arguments that are used in courts, because the very suppression the very persecution of organization and persons acting to fight against apartheid, it might constitute apartheid. Has this been, according to the Convention on the Suppression of the Crime of Apartheid, has this been used in the cases that you have taken part in? Or is it mainly on freedom of expression that you take action? Thank you.
Okay, shall we take the first question first and then go to the one for Giovanni? Yeah.
Should I start?
Yep. Please.
I mean, I think there are several issues with the Jerusalem Declaration that needs to be mentioned. One relates to what Elise said, and that it falls again in the same trap of kind of the specificity of racism. And what we see in the UK, for example, is that while every racial group or racialized group, the acts of hate and racism towards it have definitely a specificity towards them. So it's the racism against Jews is different than the racism against Blacks and so forth. And even Blacks in the UK is different than Blacks in the United States. And therefore, these definitions try to get to these kinds of specificities, but they also play into the divide and conquer idea that each racial group has to deal with the racism separately. While what we're trying to do and what we think in the UK is right, that there will be one anti-racist definition, and that will help unite the different racial groups or ethnic groups as they fight against ethnicity and racism. So that has been one voice against it. Another voice, and maybe a Palestinian on this panel can talk about it more, is the way the JDA came into being and the lack of Palestinian voices in the JDA and certain lack of concerns that are fundamental concerns for the Palestinians. And therefore, but then there's a different perspective that says, yes, the JDA has several problems, including the two that I just mentioned, but that pragmatically today it might be the best tool against the IHRA. And so we need to look at it from a pragmatic perspective. And so, for example, if I'm looking at the university sector in the UK, it seems to me that hardly any, if at all, any of the universities that adopted the IHRA will revoke it while the Tories are in government, and even the Labour Party, because it also has adopted the IHRA. So a university that we're lobbying against the IHRA in will say, on the one hand, we have students and staff that are lobbying against the IHRA definition. And on the other hand, we have the UK government that is telling us to adopt it. And it's clear which side has more weight. So one way to undermine that is tell them, okay, so adopt the JDA. And since the JDA and IHRA adopted together with the IHRA, and since they contradict each other on many points, it will make both of them inoperable, and therefore we won't have basically a definition, and they'll have to go to the Equality Act, or they'll have to go to the Human Rights Act, which is the legislation we want them to go to when there's hate speech on campus.
Thank you.
Thank you. Thank you, Neve. Giovanni, do you want to?
Yeah, okay. Yeah, I mean, on the GDA, having Neve said already everything, so I don't have more to add. Just, yeah, I mean, I reiterate, yes, but of course there are some issues actually, and also, you know, calling a declaration anti-Semitic Jerusalem, which really focus everything again on Palestine, I don't think is very useful. But again, on the other side, we need to be pragmatic. It's something that actually we are using for advocacy at university level. When it comes to the question of Francesca, no, actually, we never put forward such an argument, actually. But just to recall, what you were saying was that if you can repeat a little bit, like you said that if you could repeat in 1 second which argument, because I might not have understood completely. You're on mute, sorry.
Sorry. Yes, Article 2F of the Convention on the Suppression of the Crime of Apartheid lists the persecution.
Yeah. No, okay. Yes.
Apartheid as constituting itself.
This is an argument that has been made by lawyer Ahmed Abed in the case of the PT3P before the German court. That is the only case where I think we made that argument. I must say though that my experience, I mean, when it comes to, let's say, national tribunals, national courts, judges, I mean, yeah, they of course they took into consideration sources of international human rights law, but what usually is more effective is recalling national or European law. So usually, and this is what we saw, because in many other cases where we were indeed invoking ACH, European Convention of Human Rights or European law, the national judges are kind of reluctant to then issue a judgment making a clear referral to this source. This is what we saw, at least like in Germany and Austria. It doesn't always happen, but again, in just one case we made it, yes. And just what that, yeah, indeed, this was something that suggested as Rania Muhareb, who is an amazing PhD candidate at Galway University, and he stressed this issue a lot with us. So yeah.
Thank you, Giovanni. We have another question from Khaldoun Al-Barghouti, and it's not really directed to anyone, so please, anyone can answer it. So the question is, it says, Kenneth Stern's definition. Kenneth Stern is the one who drafted the definition of anti-Semitism. He said it's being weaponized to silence Israel, critics of Israel. How important is this confession in today's discussion? I imagine this can have so many dimensions. How important for those who are on the ground, for example, for, I don't know, for a movement like Jewish Voices for Peace. Is this used? Is this a thing? Or is this significant or insignificant? Or, yeah. Does anyone have any insights on this?
I mean, just to remind me, it is extremely significant, and actually we constantly use that article every time we have to argue against the IHRA. So yes, it is significant. It's very significant. But again, university managers and others are deaf to, I mean, not I wouldn't say are always deaf, but I would say indeed, since the huge amount of political pressure behind, this is important, is extremely significant, and is relevant. Yeah, but the other side is, of course, not enough, because yeah, the damage has been done. But yeah, we use it dozens of times.
Can I just add something? Is that we're seeing a strategy here that even using that as a way to talk about how the definition is problematic and being weaponized, that it's now said that he is off on his own and he didn't agree with others. So there's strategies to try and also undermine his statements. And that's just for people to know.
Thank you. Dr. Richard, do you want to say something?
Well, only thing I would add is that it's helpful to think about why the Jerusalem definition has been ignored while the IHRA definition has had such political traction. Why is that? And I think instructs us that law follows or is subordinate to the primacy of geopolitics. And because there's a geopolitical reinforcement and use of the IHRA definition, it's not that it's a more persuasive or more judicious formulation of anti-Semitism. It's because it's a convenient tool for geopolitical actors. And in the whole panorama of arenas that the Israel-Palestine issue arises, the primacy of geopolitics is evident, above all in the Security Council of the UN. I mean, the whole use of the veto is one expression of the subordination of law to geopolitics. And that, I think, informs our understanding of this kind of issue.
Thank you, Dr. Richard. Okay, I think we actually still have questions, but I think we are already 15 minutes past our schedule. So I would like to wrap up now, and I would like to thank again our speakers and our guests. Thank you very much for joining us today. And yeah, thanks everyone.
Thank you, William.
Thank you. Thanks, everyone.
Yep.
Thank you, everyone.
Thank you.
Bye. بنبقى أحسن.